Hello everyone, welcome to Legal Talks with CS Yatin. Today we will revisit one of the most classic and influential English case that every company law student must know. That is Ashbury Railway Carriage and Iron Company Limited versus Riche of 1875. This is the case where the House of Lords declared a simple but powerful rule. If a company acts beyond its powers, the act is void, even if every shareholder agrees to it. Ashbury Railway Carriage Company was a UK company formed to manufacture railway carriages and wagons. This was clearly stated in its object clause in the Memorandum of Association. But then, the directors made a big mistake. They decided to finance the construction of a railway line in Belgium, which was out of the object clause. They enter into a contract with Riche, a contractor to build the railway line. Later, some shareholders objected, saying the contract was beyond the company's powers. Eventually, the company refused to honor the contract, and so Riche sued the company for breach of contract. Matter finally went to House of Lords, and the House of Lords ruled in favor of company and against Riche. They held that a company cannot go beyond its object clause. Any such act is ultra vires and hence void. Even if all shareholders agree, you cannot ratify an ultra vires act. And so this is known as the famous doctrine, that is Doctrine of Ultra Vires. The Doctrine of Ultra Vires ensures that companies stick to the business they are authorized to do. It protects shareholders from misuse of funds, creditors who rely on the company's registered purpose, and public from illegal or unregulated activities. But over time, this rule has evolved. Most modern companies include wide object clauses to avoid this particular issue. In India, the doctrine of ultra vires is still relevant, especially under the Companies Act 2013. Section 4 of the Act mandates that the object clause must define the scope of the company, and the other provisions of the company law provides class action suits which can be filed if the company exceeds its object clause. To sum it up, companies must operate within their Memorandum of Association object clause. Ultra vires acts are void and can't be ratified. This protects shareholders, creditors, and public, still relevant under Indian law to restrict corporate overreach. That's why Ashbury versus Riche is not just a historic case, it's a lesson in corporate discipline. Like this video? Then don't forget to like, comment, share, and subscribe to Legal Talks with CS Yatin, where we simplify law with stories. Stay tuned for more landmark company law cases that shape legal thinking across the world.